Hello, welcome. Folks are coming in from the waiting room. We're so glad to have you here at our second National Disability Employment Awareness Month webinar. Um, we welcome you to this event. We're so excited to have you. You may have seen we are recording so that we can post this to YouTube for anyone who was not able to attend. So if you don't want to be recorded, you are always welcome to use the chat to ask questions. But with that housekeeping note, I would like to turn it over to our Commissioner for Disability, Kristen McCosh.
Thanks, Andrea. Good evening, everybody. I want to thank you for joining our webinar. As Andrea said, this is our second webinar in a series of 4 that we offer every year during National Disability Employment Awareness Month. We love this month because we love to celebrate the highlights of people with disabilities as far as employment and the contributions that they bring to employment. So we're joined tonight by partners at the state, from the Mass Office on Disability, and our colleagues in City Hall. So we have a great night with lots of information about learning your rights as an employee, learning rights as a disabled employee, and we'll have time for questions and answers. So with that, I'm going to turn it back to Andrea to introduce our speakers.
Thank you so much, Commissioner. Yes, we've got some fantastic a fantastic presentation for you today. I'm not going to say anything else, just to say welcome, Jody, from the Office of Worker Empowerment here in the city of Boston. Take it away.
Thank you so much. Thank you, Commissioner McCosh. Thank you, Andrea, for partnering with us on this webinar. So my name is Jody Sugarman Brozan, and I am the director of the Office of Labor Compliance and Worker Protection. So I am going to share with you all some general workers' rights information. There's a lot of information on these slides. I'm going to move extremely quickly and then put in the link, the website, where you can get lots more detail and information on this, what I'm about to share with you this evening. And I believe these slides will be available as well as the recording. So I always want to start by saying that almost all of the rights that I'm about to share with you all are apply to all workers, regardless of immigration status. The only things that I may share this evening that don't apply are undocumented immigrants aren't able to receive unemployment benefits. Otherwise, all the rights that I am sharing with you apply. And I'm going to start with wage and hour, which is really important. The minimum wage in Massachusetts is $15 per hour, unless you're an agricultural worker, then it is $8 an hour. You must see the poster that you see here on this slide at your workplace to give all kinds of details about your rights, and particularly rights around wages. The other difference, or the other exception here, is if you are a restaurant or tipped worker, a service employee. And in that case, you have to make at least $6.75 an hour. However, your tips plus your hourly wage must still make up that $15 per hour. And if it doesn't, your employer has to make the difference. Unfortunately, it is dependent upon the worker to keep track of this. So I encourage anybody who is a tipped service employee to track their hours, track their tips, make sure you are making that $15 an hour, and reach out to your employer to ensure you are being paid the difference. If you work more than 40 hours a week, you are eligible for overtime in Massachusetts. So if you make $18 an hour, if you work over $40 an hour, 40 hours, you should make $27 for every hour over 40. There are some exceptions to this, but it's important to know this, especially if you're an hourly worker. Paid in a timely manner. Eventually, it depends on how many days. If you work 5 or 6 days per week, you have to be paid 6 days after your pay period ends. And if you work 1 to 4 or 7 days, you get that your employer gets that extra day. One thing that is really important that I like to point out is that if you quit your job, you must be paid in full on the next regular payday. However, if you are fired or laid off, your employer must have your full paycheck inclusive of all of your owed vacation time, on the day that you are fired or laid off. Pay stub seems very simple, but this is actually something that labor folks fought really hard because it's hard to tell if you've been paid properly if you don't have a pay stub with the proper information. So Massachusetts law requires that you get a pay stub with the name of your employer, the date of the payment, the number of hours you've worked, and the hourly rate, and any deductions made. And you can't be charged to be, if you have this provided for you electronically, you have to have a way to print it out as well. Pay deductions, again, there's a lot of information on this slide. I will definitely share a link in the chat, but the main thing I'd like to point out here is that employers can only deduct what law allows, withholding taxes and wage taxes and things like that, but they cannot deduct for materials or tools, and especially a uniform. If an employer requires a worker to buy or rent a uniform, then they have to promptly refund the cost to the worker. So they should not be deducting your uniform without paying you back for that. This is another really important law that was passed in Massachusetts. The Earned Sick Time Law is people fought really hard to get this law. It requires that most workers in Massachusetts have the right to earn and use up to 40 hours of job protected sick time. So you must earn at least 1 hour of sick time for every 30 hours worked, and employers with 11 or more employees must provide that as paid sick time. If you work for someone with 11 or fewer employees, it doesn't have to be paid, but you must be afforded that sick time. Your employer must have a policy for this, and you must be able to utilize this work time, the sick time, to take care of yourself or certain family members. And again, this was something that is a fairly new law in Massachusetts that workers fought really hard to get on the books. The Mass Parental Leave Act requires employers with 6 or more employees to provide no fewer than 8 weeks of unpaid leave to employees for the birth or adoption of a child. This is another really important law. You have to provide at least 2 weeks notice and state your intention to return. It is not paid, but you are guaranteed your job back if you utilize this time. Again, this is a law that's somewhat unique to Massachusetts, so I want to make sure people really know about this law. And this is another, I keep saying, but it is, you also have the right to paid family medical leave. And this is one that is not open to folks who are undocumented, because you must be paid on a W-2 with taxes deducted and meet minimum earning requirements. So as long as if you have work authorization and you're paid via W-2, you are eligible. But for most Massachusetts employees, you can take leave for a qualifying reason, and those reasons are listed here on the slide: caring for your own serious health condition, or a family member with a serious health condition, or bonding with your child during the first 12 months after birth or adoption. And this is, you will notice that there are deductions on your paycheck that are being provided to the state of Massachusetts to pay for this. So you are eligible to take this time. And the funds are deducted from your paycheck, every paycheck, to help provide for this program. And then I am not going to go into too much detail about about your rights to work in a workplace free of discrimination, because my colleagues from the Massachusetts Office of Disability are here, and they will be talking a lot more about this. But as most folks know, there are laws in Massachusetts that require that outlaw treating people unfairly based on membership in a protected class, and those protected classes are listed here. And these laws apply to employers with 6 or more employees in Massachusetts. Federal laws are applied to 15 or more employees. So my colleague will go into much more detail about this, but I do have this listed here. And similarly to discrimination, you are you cannot, your employer has to create a workplace free of sexual harassment. This slide gave most of the details, but the information that I think is important is that your employer must have a written policy around sexual harassment. It's required by Massachusetts law, and that policy must not only address whether or not address sexual harassment committed by persons with a parent or actual supervisory authority, but also coworkers, and in some cases, even clients and patients. So very important. You also have a right to a workplace free of health and safety. You have the right to a safe and healthy workplace, and that includes having the training that you need to be safe on the job. It requires that you have the correct safety equipment. It requires that you are able to understand and know what toxic chemicals you may be working with, and many in a place where you're risk of falling. There are laws around fall protection. If you work at a place where you may be exposed to chemicals, there are hazard communication requirements. So there are OSHA provides, your employer must tell you what potential hazards you will be exposed to and provide you with the proper training and protections. And you also have the right to speak up without fear of retaliation if you feel you are working in an unlaws focused on retaliation. If an employer retaliates against a worker for speaking up and reporting unsafe conditions, they can be fined even more significantly than some of the actual health and safety violations. In Boston, I just am really excited to say that we just passed a new law that is going to require some heat illness prevention plan and heat protections for certain workers in the city. We are among the first municipalities to pass a law that provides these protections. So stay tuned. We will be rolling this out in time for summer of 2026. And I'm very excited to see Boston really becoming both a model employer and taking the lead in these protections. And if you are insured, you right to work insurance. Workers' compensation is insurance that your employer pays for. So if you are injured, or if you are permanently injured, workers' compensation can pay you more than just the time until you return. You have the right to workers' compensation insurance if you are injured on the job, regardless of how many jobs you have, whether or not you're paid in cash, or whether or not you regardless of your immigration status. And it will provide 60% of your average weekly pay if you cannot work for 5 days or more. It also provides transportation costs for medical visits and payments if you cannot return to work because of the injury. And I said a little bit about the heat prevention. Oops, I'm going up instead of down. You also have the right to organize, and that means that you can come together with coworkers to discuss work issues and organize about those issues to take action without fear of retaliation. That is a federal law. And finally, domestic workers in Massachusetts have specific rights as well. There's something called the Domestic Workers Bill of Rights, which allows workers who work in the home to have, including housekeeping, cleaning, home management, childcare, to have a right to a minimum wage, overtime, time off from work, and other protections. And again, I just can't highlight this enough. Your employer cannot retaliate against you for asserting your rights. And that can mean any number of things, from calling or threatening to call immigration, threatening worker or family, firing or reducing pay hours. This is all illegal retaliation. And it's very illegal for an employer to do this, and this is enforced by OSHA. That is all for me this evening.
Thank you so much, Jody. That is definitely a lot of information, so many rights that's important folks know about. I did note in the chat, if people had questions, they can throw them in the chat, but this is also the time where we will pause and ask if you have a question that you don't want to put in the chat, if you would like to voice it or sign it, please use the raised hand function or just put your hand up if your camera's on, and I can call on you to ask your question. I do have one question, Jody, maybe if you can answer. As part of National Disability Employment Awareness Month, we also do a webinar about jobs with the city. And I know people who are on this webinar may be interested in applying for jobs with the city. With these rights to, a pay stub and to a safe work environment, would those also apply to City of Boston jobs?
Absolutely. All these laws apply to public sector workers or private sector workers. Interestingly, around the country, OSHA and health and safety laws only cover private sector workers, but here in Massachusetts, we passed what's called the public sector OSHA law. So we are protected by the same standards as OSHA as enforced by our Massachusetts Department of Labor standards. So yes, all these rights apply to City of Boston workers as well as private sector workers.
Thank you so much for that. Wonderful. Well, I'm not seeing any other questions in the chat at this time. So I will say thank you again to Jody. I believe you'll be staying on. So if folks do think of questions after the fact, as they come up, please feel free to continue to throw them in the chat, and Jody can engage and answer them with you. As Jody alluded to earlier in the presentation, we have a second presenter here today to talk in a little bit more specifics about specific rights that do apply to people who are disabled. And so with that, I would like to introduce the Massachusetts Office on Disability, Alan Monteco.
Thank you, Andrea, and thank you to Commissioner McCosh and yourself and Colleen and the folks from your staff for having me this evening, and I'm pleased to share some slides with you all and walk through those with you. All right, well, good evening, everybody. And so, again, my name is Alan Monteco. I'm the Executive Director of the Mass Office on Disability, and pleased to be with you. I joined MOD, rejoined MOD in April of this year after working there about 10 years ago and doing a number of other roles in state government related to disability rights and diversity and equal opportunity, and pleased to rejoin colleagues at MOD who are focused solely every day on how to ensure access and opportunity for people with disabilities across the Commonwealth. I'm going to spend a little bit of time talking to you about some of the protections that are afforded to people in the workplace based on disability. This could probably be, as I'm sure was true for Jody's material, a 90-minute or 2-hour class or something along those lines. We'll probably try to get through it in about 10 or 15 minutes. But certainly if there are questions, happy to answer those afterwards. So there are sort of two basic protections afforded to people with disabilities under the Americans with Disabilities Act. And those are, number one, non-discrimination. What does that mean? Really, it means protection from deliberate action, inaction, or different treatment because of your disability. So you're protected from those illegal behaviors. And then you're also afforded the right to what's called reasonable accommodation, which is a change in or exception of policies or procedures or any aspect of the work environment or process that enables an individual with a disability to have equal access to perform the functions of the position, to apply for a position, to get the benefits and privileges of positions, et cetera. These are protections based on one's disability, and they're evaluated on a case-by-case basis. And we will talk a little bit further in terms of the basis for why an accommodation might be denied, but you can just sort of generally see there fundamental alteration, undue hardship, direct threat, or lack of establishing evidence of a disability. We'll talk about more of those, each of those in turn as we move forward. So at the outset, I think a lot of folks often wonder sort of what is my obligation? What is my responsibility? When should I or should I not disclose information about my disability? A couple things to keep in mind with respect to disclosure of disability. First and foremost, the decision to disclose or not disclose your disability in any way, shape, or form in the workplace is yours and yours alone. It's a voluntary and personal decision that we encourage each person to make based on their own sense of self and sense of morals and sense of circumstances and the nature of their job and the nature of their job duties and the nature of their disability. So it's not a one-size-fits-all decision by any means. Disclosing information about your disability in the workplace generally takes two forms. One is what we will just call sort of self-disclosure, and that is the sort of basic disclosure of your disability to anybody that you work with for any reason. It can be for formal reasons, it can be for informal reasons, it can be off the cuff, it can be planned. Just the general disclosure of your disability in the workplace. It's a decision to be made. It's not a decision without some consequence, and so we typically just call that self-disclosure. There's also the notion of self-identification, which is something that most but not all employers have a process for, whereby an individual can disclose their disability for affirmative action purposes, protection from things like layoff or reduction in force, or to obtain some kind of workplace benefit or protection, such as a reasonable accommodation. One might choose to self-identify. In some workplaces, self-identification and reasonable accommodation are very much separate, such as if you work for the government. Those are two very separate processes. Other places that you might work, such as a smaller business, they may commingle the idea of self-identification and reasonable accommodation. But in general, just know that there's a formal process to disclose your disability for purposes of some kind of employment benefit. And then there's the informal process of disclosing your disability for really any other reason that you might choose to share that part of yourself with folks that you work with. So I guess I kind of got a little ahead of myself with respect to self-identification. Generally, self-identification, as it says here, can qualify employees for affirmative action status with respect to hiring or promotion or prevention from layoffs. It also, in a workplace does allow the employer to better understand the nature of the workforce, who's in the workforce, to know the demographics of the workforce. It helps address issues of stigma so that an employer can ensure that everyone feels as though the workplace is a safe and welcoming place. And whether you're disclosing for informal or formal reasons, know that any disclosure of disability-related information in the workplace always must be kept confidential by your employer. Disability-related information of any kind can only be shared on a need-to-know basis, and certainly any kind of informal disclosure or formal disclosure for self-identification purposes is going to need to be known on a very, very limited scope, and so really won't need to be shared beyond the individual or individuals that you choose to share it with. Now, with respect to when you might want to reach out to HR or a ADA coordinator in your workplace regarding your disability, beyond just the concept of disclosure, a couple of different scenarios where that might come up. First, if you know that you need some kind of tool or device to effectively do your job because of a disability, if you need to modify your work schedule due to your disability to attend appointments or to deal with other aspects of a flare-up of your condition, if you're encountering a barrier at work related to your disability, and that barrier could be physical, it could be procedural, it could be relational. If you need any other kind of change due to your disability, whether that's an issue of policy or procedure, or just the way that things kind of happen in the workplace, things that are informal, or if you're having trouble with an aspect of your job, if your performance is suffering because of your disability, those are some of the reasons that we encourage you to reach out to your HR or ADA coordinator. Now, most employers will have an ADA coordinator, someone that's identified as an ADA coordinator. Some employers will do a better job than others of publicizing who that person is. But in general, if in doubt as to who that is and you're unable to find that on the website or the intranet site for your company, you can always reach out to the HR folks, and they're the ones who are ultimately responsible for knowing who to connect you to in an organization. When we talk about a reasonable accommodation, technically, a reasonable accommodation is any potential adjustment or alteration to a workplace that enables a person with a disability to apply for a position, to perform the essential functions of their job, or to enjoy what are called the benefits and privileges of employment. It's really important here to keep in mind that any adjustment or alteration to the workplace of any kind, anything that you can conceive of, even if that means you want to request that every chair in the workplace be reupholstered to be the American flag, everything is on the table for you as the person with a disability to ask for what it is that you think you need to meet your disability-related limitations in the workplace and to enable you to be successful. It doesn't mean that just because you ask for anything or everything that you're going to get it, but you really should not be constrained in what you ask for by what you think your employer may or may not grant. That's a whole separate part of the process. Accommodations generally fall into a couple of different sort of broad categories. We think about auxiliary aids and services to help effectuate effective communication. We think about equipment, whether that's software or other pieces of technology that help people perform their job duties, removal of physical or procedural barriers, and then modifications or reasonable modifications of policies or processes. With respect to the request process itself, it's important to keep in mind that although many employers will tell you that certain accommodation requests need to be in writing or need to be on a specific form, in fact, that's not really the case. A verbal request can and should and is sufficient to kickstart the request process. A request need not be in writing. It's not unreasonable for an employer to ask you to ultimately put your request in writing, but it can't be a barrier to starting the process or beginning to engage with you about your request. And so don't feel as though just because you may have mentioned it and then nobody's followed up on it that you've done something wrong. It can be very informal with respect to how you initially lodge it, even if it becomes more formal as the process goes forward. Having said that, ultimately to get an accommodation, there is certain information you're going to have to tell your employer. And I know that both employees and their medical providers are often, a little bit understandably cautious or understandably concerned about how much information you disclose about their disability in the workplace. And so it's helpful to really be keying in on what it is that your employer has the right to know when you're requesting an accommodation. First, they have the right to know that you are, in fact, a person with a disability, that your medical condition, whether it's a physical condition, a mental health condition, a cognitive, emotional condition, whatever it may be, that it's not just a transient or minor or passing condition. It's something that does rise to the level of being a disabling condition, which is one that substantially limits you in a major life activity or bodily system. That the medical condition affects your ability to perform an essential function of your job or to access a benefit or privilege of employment. And that the employer has the right to know what the sort of functional limitation that you have is, what the medical condition impacts you from being able to perform in the workplace. So what I usually tell folks is the employer has the right to know the nature, the severity, and the duration of your medical condition, not necessarily the name of it. And then they have the right to know in what ways relative to your work does the condition actually affect you when it comes to doing your job, major job duties. And then the employer has the right to know what it is that, in fact, you're asking for. They're not obligated to be a mind reader. So just because, they know you have an issue with your vision doesn't mean they're obligated to know that you need a larger monitor for your computer, or just because you have an issue with your knee doesn't obligate them to know that you need some kind of modification to your obligation to walk on the job or to bend or to lift. You need to tell them what it is that you need. And indeed, that is to your advantage because it's designed, the accommodation process is designed to give you the modification to your job that is going to enable you to be successful based on your job and your medical condition. And just because someone else might request something else in your same condition or in your same shoes doesn't mean that's going to work for you. So again, you're telling your employer and verifying for your employer that yes, you have a disability, These are the functional limitations caused by the disability, and this is the accommodation or accommodations that you're asking for as a result. If the disability is not obvious or the accommodation you're requesting is not obvious, and again, the example I've used there is someone who, to combine my earlier examples, someone who's got someone who's got a knee injury but asks for like a 36-inch computer monitor. It may be obvious that you have a knee injury. They may know that you went in for ACL surgery, but it might not be obvious why that correlates to needing a larger monitor. So whether the disability is not obvious or the requested accommodation isn't obvious, the employer does have the right to ask for medical documentation from your healthcare provider. Doesn't necessarily mean it's a physician. It can be a nurse practitioner, physician's assistant, physical therapist, speech therapist, someone of that ilk. But medical documentation that confirms the nature of your disability and the connection between that and the accommodation that you're asking for. Once you've made the accommodation request, your employer is then obligated, and it says the employer will. They should, right? We're talking about what should happen. The employer should reach out to you to begin what's called the interactive process or interactive dialogue. And that's basically a fancy legal term for engaging you in an ongoing conversation about trying to understand what the medical limitations that you have are, how they affect your job, and what it is that you need to be requesting as an accommodation and whether or not the employer can provide that. And that interactive process, that interactive dialogue, that ongoing conversation goes on for as long as it takes for the employee and employer to hopefully reach an outcome whereby the employee gets an accommodation that's effective to meet their disability-related needs, and the needs of the business are also being met. At some point there may also be some kind of impasse, but hopefully the interactive process facilitates an effective and positive outcome for everybody. And just to be clear, an employee gets not necessarily always the accommodation that they ask for. They get an accommodation. You're entitled to an accommodation in the workplace that meets your disability-related needs based on the information you provide without causing some kind of undue hardship or fundamental alteration to your business. So the easiest example here to think about is, people that have seasonal affective disorder may need a lamp or light to help them deal with their seasonal affective disorder in the workplace. Just because you might go online to the Sharper Image catalog and find a lamp that costs $4,000 doesn't mean that that's the individual lamp that your employer has to buy you. They have to just buy you a lamp that your doctor and you agree is going to meet your seasonal affective disorder related needs. And if that lamp costs $4,000, that's what it costs. But if it costs $40 and is just as effective as the $4,000 one, then that's the one that your employer needs to provide. But that's where the interactive process comes in to really help folks sort through the different options and get to a resolution. So if you've made a request for accommodation, why might it be denied? Well, first, if it creates what's called an undue financial or administrative burden for the employer, they're not obligated to provide it. Undue burden, whether financial or administrative, is really a very high bar. It's a significant level of expense or significant level of difficulty based on the overall financial wherewithal of your employer, based on the overall administrative capacity of your employer. So it's not just that something might be difficult for the employer or a little bit challenging. The employer has to demonstrate that providing the accommodation would be a significant barrier. And by its very nature, an accommodation is going to ask an employer to do something other than what they might otherwise ordinarily choose to do. So the idea that it's a little bit different isn't in and of itself an undue burden. It really has to be a pretty high bar. If something would fundamentally alter the nature of the job, and the better way to sort of think about this is, every job has a list of job functions. Some jobs have 5 job functions, some jobs have 3 job functions, some jobs have 15 job functions. Whatever number of functions are on your job description, there's some number of those that are typically the essential functions of a job, which are the sort of the key functions, the core functions. The reason the job exists are to perform these few functions. And so if a accommodation request would significantly alter one of those essential functions or remove an essential function, then that would typically qualify as an unreasonable request, or something that we might call sort of fundamentally altering the nature of the job. If a particular accommodation request would be a direct threat to either your health and safety, the health and safety of a coworker, or the health and safety of the people that you serve in your job as customers, an accommodation does not need to be provided. So again, I like to use examples that are sort of to the extreme to just illustrate a point. It may very well be that someone has some kind of the example I always use is nunchucks. It may be that having access to nunchucks at work give you some kind of comfort from anxiety because they serve as a source of protection. Um, but if there's a history or reason to believe that you having the nunchucks in the office might be a direct threat to someone's health and safety, they're not obligated to allow you to have the nunchucks, even if they're effective at their presence being a source of calm for you. And then the other thing is that reasonable accommodations are only given out for disability related reasons. There's any number of things that people might ask for in the workplace that make their job easier or more tolerable or um, uh, more conducive to them being effective and performing well. But an accommodation that's not very specifically rooted and needed because of a disability isn't a reasonable accommodation. So things that you might ask for out of convenience, things that you might ask for due to the medical condition of a loved one or a family member, or things that might be asked for financial reasons that aren't related to a medical condition that you yourself have would not be considered a reasonable accommodation. So things to think about as you go through this process are, is the situation that happened? And now we're talking about whether you're asking for an accommodation or whether you're talking about that you think you might be a victim of some kind of disability discrimination, either because of something that happened or something that didn't happen. You want to be asking whether that situation that you're concerned about happened or didn't happen because of your disability. And if it is because of your disability, then it's certainly possible that it might be an issue of discrimination. If you can't tie what has happened to being because of your disability or potentially because of your disability, then it may not be right. It may not be fair. It may not even be legal, but it's not disability discrimination. When in doubt, there's a number of resources certainly that you can call. We want the Mass Office on Disability to be one of those resources that you keep in mind. We're here to serve folks not only in the city of Boston, but from Provincetown to Pittsfield and everywhere in between. And we do help folks from out of the state when it comes to issues that relate to Massachusetts. So we're here to serve. We're here to serve the public. People with disabilities who face discrimination in the workplace have the right to file complaints at the Mass Commission Against Discrimination, as well as the Equal Employment Opportunity Commission. Certainly encourage you to reach out to some of the resources like MOD before you go to the MCAD or the EOC. Not that that's a requirement, but we encourage it just because we often can help you to sort of make sure that you are considering all the different aspects of your situation, that you've sort of exhausted potential remedies short of filing a complaint, because even under the best of circumstances, a complaint process can take a long time and doesn't always result in the outcome that it should or that you hope for. MOD, in the slide deck that'll be shared and be available, has a disability rights and employment website. If you're following along at home, it's mass.gov/MOD. And you can access the information there. It's a pretty robust page. We also have information about other topics related to disability, like housing and public accommodations. Our phone number is 617-727-7440. We are open Monday through Friday, regular business hours. We work to help people understand their rights and obligations under all of the relevant disability laws, not just the ADA. And try to help people find resolutions that meet their needs and are effective. We try to make good referrals when possible. And you should also know that the services that we provide are of no cost to both residents and non-residents of Massachusetts and are not subject to residency requirements or immigration-related requirements. And with that, we'll take any questions that you might have.
Thank you so much, Alan. That was such a well compact, tightly compact overview of what I know is quite a complex law and situation. So, like Alan said, time for questions. If folks would like to put them in the chat, use the Zoom raise hand function or raise your hand with your camera on. While I give folks a minute to see if they would like to ask any questions, I will ask one similar to what I asked Jody. Alan, did these rights apply if you are applying for a City of Boston job or if you are in City of Boston employment?
Yes, absolutely. That's keeps it simple. 100%. It applies to government jobs, non-government jobs. As I think the previous presenter mentioned, most of the protections related to employees with disabilities in Massachusetts apply to any employer with more than 6 employees.
Thank you so much. Yes, we like to ask that question because we here at the Disabilities Commission enforce Title II, which is not the same as employment, but that's not to say that Title I rights to employment don't apply in the City of Boston. Love
Right.
to make it absolutely clear to folks that these rights do exist if you are applying to the city, if you work for the city, our city or any other city in Massachusetts.
I would actually go a step further and say I think that government tends to be one of the more accommodating employers for individuals with disabilities generally. And so if you're somebody out there who's looking to pursue potential new employment, and you know that you're a person with a disability who tends to need an accommodation in the workforce, I think government, whether it be at the city level or at the state level, tends to be a welcoming place for people with disabilities. Not to say that there aren't more other welcoming places, but we tend to be pretty understanding and pretty accommodating in government. So,
Alan, I had a question. It's Commissioner McCosh.
yeah, fire away.
I'm wondering, do these protections apply to people who are applying for jobs as well? Can you talk about asking for a reasonable accommodation
Great.
as an applicant?
Great question, Commissioner. Yeah, they do. So the anti-discrimination protections absolutely apply. And the issue of disclosure and accommodations in the application process is very different in some ways, though, from when you do that once you've actually received a position. And here's why. First of all, you're not obligated to disclose anything about a disability in any way, nor can nearly anyone as an employer ask you about a disability until an offer is made. So unless you choose to or think you need to disclose anything about your disability, just know that that doesn't really come up until you get to the offer stage. Having said that, there are people who find that they need some kind of accommodation or may need an accommodation to participate in the application process, whether that's because they need to get some assistance accessing the online application system or submitting their application through the mail, or they have a disability-related need that might arise during the interview process, whether that's because they have the need for some additional time to consider some questions, or whether the employer tells you that they might be doing some kind of test for all applicants, like a typing test or a writing test. It's important to know that you can ask for accommodations that are just related to the application process or the interview process that have no relationship to or no requirements related to whether you actually get the job. So, for example, if you know that you're going to sit for an interview for a company that requires a typing test and you think that you might need an accommodation due to your disability for the typing test, but might not need one if you were to actually get the position, that's quite all right. The same is true in reverse, which is to say, if you decide, you know what, I don't really want to disclose my disability during the application process, I'm worried what that might sort of connote, even though it shouldn't connote anything. If you don't request it in the application process, but ultimately decide you need one, if you were to get the position, that's okay too. So there are accommodations just for the application process. And I would also just add that an employer's obligation to provide accommodations in the application process or the interview process is not the same either. They have a greater obligation to provide an accommodation in the interview or application process oftentimes than they do on the job. And again, we go back to that example of a typing related accommodation. It may not be that they can exempt somebody from performing typing or computer-based work in a particular job because of the essential functions of that job. But it may be that in a particular interview for a position where they might give a typing test, they might be able to exempt someone from that typing test or give them an accommodation on that typing test if doing so just for that purpose is reasonable, right? And so that's why we say all of these things are always case by case. But absolutely, from the moment you're considering a position to the moment you accept a position to the day you leave a position, you always have the right to request accommodations, to have those accommodation requests sort of heard and considered and subject to the interactive process. And from the very beginning, you also have the right to expect that you're not going to be discriminated against or treated differently because of your disability. So hope that was helpful. That was kind of a lot. I apologize.
No, that was very helpful. And you preemptively asked a question that I was going to pose, which is there a deadline by which you have to request the accommodation?
No.
Otherwise, you miss your chance.
Nope, there's never a deadline. You request it when it makes the most sense for you. I will say that, it is common for us at MOD to get calls from people who, for understandable reasons, want to not disclose their disability up front and may wait until they hit some kind of performance issue before they choose to disclose. And that's okay. But what I always tell folks is you want to be cautious about not waiting too long, because there is a point at which, while it's never too late to request an accommodation, it may be too late to really salvage the performance issues that are underlying your work to that point. And accommodations in work are typically given prospectively, meaning moving forward. They're not typically reason to waive, let's say, discipline or poor performance that's happened in the past before you've requested the accommodation. So if you wait until the sort of very last minute before you're about to be, let's say, let go for performance reasons, and then you wait to request your accommodation, it's not going to help you absolve all the stuff that's happened. The sooner that you know that your disability might be related to the performance issue that you're having, the sooner that your employer can help you work through that, the greater the likelihood that you're going to be able to salvage your position and really begin to excel if you get the accommodations that you need to be successful.
One way I've heard this question asked is, can I request lower performance evaluation standards for myself as a reasonable accommodation? Is the employer required to do that?
Generally speaking, the answer to that is no. In very limited circumstances, for limited periods of time, which might include things like a demotion, that can occur, but generally no, that employer is not obligated to lower the performance standards or expectations of a position just because of someone's disability. And in fact, if that's something that you ask for, you're likely to be denied that request. That's going to be considered sort of a fundamental alteration to the job.
Makes sense. I'm not seeing any questions in the chat. So I'm once again going to scroll through our attendees. If you have a question for Alan or Jody, who is still here, please feel free to raise your Zoom hand using the Zoom raise hand function, or turn on your camera and wave at it. I will see you wave at it and can call on you for your question. Not seeing anything coming up. Are there any final thoughts or comments that you have, Alan or Jody? I can bring you back on camera. Any closing advice or links to drop in the chat for our attendees here?
I certainly can drop MOD's website. I would just say that, this is all of the stuff that was presented tonight, although I think Jody did a fantastic job. All of this stuff, when it applies to you, can become complex overnight. And so, when in doubt, this is what we're here for. We're here to help people sort through these issues as they apply to their personal lives. And so, don't hesitate to reach out to us. You're not inconveniencing anybody. You're not being difficult. We exist to help and to serve. And so, please let us do that.
I would echo the same. We are here. You can reach us at workers@boston.gov. We also will be setting up a series of workers' rights office hours at BCYF and other facilities around the city. The schedule will be on our website. So if you have questions, please come see us at these workers' rights office hours. We can help answer questions and make referrals.
Wonderful. Thank you so much, Alan. Thank you so much, Jody, for being here, taking the time to share this information. I know you do this every day, and you've got great staff on your teams as well who answer folks' questions. But this video will be on YouTube. For those of you seeing it online, please go to mass.gov/MOD or boston.gov/workers workers-rights. Those are the links that are in our chat here, but those are some great resources for you in your search for advice as a worker. With that, we'll close out the second of our Wednesday webinars celebrating National Disability Employment Awareness Month. Our next session will be on financial empowerment tools available here at the City of Boston with the Office of Workers Empowerment. And we hope to see you on the 15th for that session. Thank you so much.